It is also quite fitting that this hearing is held in the Tom Lantos Human Rights Commission, as the very first hearing on international parental child abduction was held by the Commission back in December of 2009. I would say again for the record, since it wasn't caught in the beginning, we are now at the 5th year of the Sean and David Goldman International Child Abduction Prevention and Return Act. We passed it 5 years to the day in Congress, and then it headed down to the President for signature. My colleagues and Commission Co-Chair Jim McGovern was actually at that hearing, as was Patricia Appy, who is here with us today and will testify. Patricia was David Goldman's incredibly effective attorney during an arduous 5-year ordeal in Brazil, and had a great strategy, a legal strategy that thankfully in the end worked. But she's here to shed some light on where we should be going and where we need to make any changes. Every year, approximately 450 American children are unlawfully removed from their homes by one of their parents and taken across international borders. The victims of international parental child abduction include not only children who are denied the love and attention of one of their parents, but also parents cut off from the children that they so deeply love. If there is good news to be had, is that when we had our first hearing on implementation of the Goldman Act in March of 2015, some 1,000 American children a year were being victimized. We have seen since that what appears to be a consistent downward reduction in the number of children being kidnapped each year, at least into some parts of the world. One reason I think we have seen a reduction is because the annual report, which the State Department files on parental child abduction, and a very proactive and very robust program to try to mitigate those abductions. One of the objectives of the report is to alert family court judges about which countries are high risk in terms of failure to return abducted children, notwithstanding the fact that a country may have ratified the Hague Convention on the civil aspects of international child abduction. The report now is much more accurate, and it's also user-friendly than it has been in the past. So thank you for that. I say to our distinguished witness, who will speak in a moment, including both convention and non-convention countries, identifying recent developments and warning of enhanced obstacles to the recovery of children. For this, I want to say, again, commend Assistant Secretary Risch for his team. It is impossible to tell how many kidnappings may have been averted, yet one would think that credit should be due, at least in part, to the report and to the work that you're doing, so thank you. However, for many left-behind parents in the audience today, and those who couldn't join us today but are watching and are deeply concerned, this is scant consolation. These parents have not seen their children in years, even decades. These parents know all too well the financial, legal, cultural, linguistic barriers to bringing their children home from a foreign country. These parents are well acquainted with heartbreak, agony, and pain. And that pain is compounded by knowing that suffering caused to your child is by this separation. Child abduction, let's be clear about it, is child abuse. As the State Department itself noted in its 2010 report on compliance with the Hague Convention, quote, abducted children are at risk of serious emotional and psychological problems. Research shows that recovered children often experience a range of problems, including anxiety, eating problems, nightmares, mood swings, sleep disturbances, aggressive behavior, resentment, guilt, and fearfulness. As adults, individuals who have been abducted as children may struggle with identity issues, personal relationships, and possibly experience problems in parenting their own children, close quote. These young victims, like their left-behind parents, are American citizens who need the help of their government when normal legal processes are unavailable or have failed. To that end, in 1988, the United States ratified the Hague Convention on the civil aspects of international child abduction to try to address abduction and access. The Hague Convention creates a civil framework for the quick return of abducted children and for rights of access for left-behind parents. Absent extenuating circumstances, the child is to be returned within 6 weeks to his or her country of habitual residence for the courts there to decide on custody or to enforce any previous custody determinations. The convention has helped some left-behind parents be reunited with their children, no doubt about it, but there are many who are still left behind. Some Hague Convention parties are simply not enforcing legitimate return orders. These include, according to the report, Argentina, Brazil, Ecuador, and Peru, countries which have ratified the convention but failed to live up to their commitments. There are also other non-Hague countries that are listed in the 2019 report as demonstrating a pattern of noncompliance. In other words, countries that habitually fail to enforce return orders, which include Egypt, India, Jordan, Lebanon, and the United Arab Emirates. In short, abducted American children are not coming home from these countries and other countries where the convention operates weakly or with which the U.S. has no bilateral agreement of any kind. One country which has been previously listed as non-compliant but was delisted in the 2019 report is Japan, ostensibly because it has legislation advancing in its national diet or parliament, which would address returns in Hague cases and enforcement of return orders. While that may be a positive development, though how positive remains to be seen, it does nothing to address the reported 18 open pre-Hague ratification cases where there's been no progress at all, even in cases where parents are simply seeking access to their children under the convention. Why is Japan a problem? It's a matter of practical matter. Many of the victimized parents are members of our armed forces stationed in Japan who marry Japanese nationals. Given the sacrifice of our soldiers, sailors, and Marines and airmen, we should especially solicitous of their struggles. We should go the extra mile, given the fact that they are deployed there to protect the people of Japan in that region. We have fathers like Captain Navy Paul Tolan, who has testified at previous hearings that I have chaired, whose daughter Erica was abducted and who now is the sole surviving parent, yet still cannot get access to his daughter, who remains with her grandmother in Japan. Or Michael Elias from New Jersey, a Marine stationed in Okinawa, whose 2 children were abducted after he was deployed in Iraq, where he suffered a terrible wound from an IED. His wife, who worked in the Japanese consulate, used her influence to obtain Japanese passports illegally and kidnapped their children. Michael has not seen his children, Jade and Michael Jr., since 2008. As a matter of fact, I actually traveled to Japan with his grandparents, the grandparents of the kids, and we could not get access. We ran into a brick wall when we talked to Japanese leaders about this egregious violation of international human rights norms, and he still has not seen his kids. Again, this is absolutely unacceptable, and it's also inexplicable why no progress has been made in crafting a supplemental bilateral agreement with Japan to address both pre-Hague return and access rates. And I do hope our distinguished witness will speak to the need for that. India is another country with a deplorable record when it comes to returning abducted children. While many Indian government officials and judges have encouraged Hague accession, attorneys and lobbyists involved in domestic relations matters oppose accession and returns due to a cultural preference for keeping children with their mothers and a purported concern that ratifying the Hague would disadvantage Indian mothers who have fled abusive marriages abroad. Such claims are belied, however, by the testimony of one of our witnesses today, Ruchika Abbey, the mother of a child abducted to India, as well as previous witnesses who have testified before my committee, including Bindu Phillips, who lives in New Jersey, whose children were also abducted to India by her husband. Part of the intent of the Goldman Act was to simply to reform the system. It wasn't just to do that, but to bring about a fundamental sea change in U.S. diplomacy so that State Department officials would see themselves as advocates for the return of abducted American children. The Act also provides the State Department with real tools to use in their advocacy, including sanctions. The Goldman Act specifically lists increasingly escalating actions from a demarche or a protest through diplomatic channels to public condemnation to a delay or cancellation of one or more bilateral visits, and even withdrawal, limitation, or suspension of foreign assistance to the central government of a country. Extradition is another tool. Yet these tools beyond demarches seem to be seldom, if ever, used by the Department of State. I would ask Assistant Secretary Risch to answer, if he would, why? Why don't we use these other tools that are in the toolbox? And I really do want to call upon the members of our State Department to see themselves really as advocates for heartbroken American parents and equally for their children, and remind them that a tough approach will yield results if consistently and persistently applied. We saw that in the case of Sean and David Goldman. We have seen it in other. Bill Posey recently threatened sanctions against Lebanon in June of this year, resulting in the resolution of two longstanding abduction cases. And that's why they resolved it, because they were threatened with those sanctions. To sum up, the message I have for the State Department, standing up for Americans, is the duty of everyone. It's our duty, your duty, and we will do as best we can to do that. I'd like to yield to our distinguished member of the commission, Dr. Harris, Andy Harris, for anything you'd like to say.
No, thank you very much, and thank you very much, Mr. Chairman, for holding the hearing. As you know, over the years, we've worked together on a case that we have in Mara District dealing with Trinidad. An unusual circumstance there where the abduction occurred before the Trinidad joined the Hague Convention, but nonetheless that points out the difficulty that American parents sometimes have dealing with foreign governments and how useful the State Department can be in some ways helping mediate those very difficult situations. So I appreciate you being here, appearing before the committee, and thank you, Mr. Chairman, for holding the hearing.
Thank you very much, Commissioner. I'd like to now turn the floor to our distinguished first witness from the administration. Carl C. Risch was sworn in as Assistant Secretary of State for Consular Affairs in August 11th of 2017. Secretary Risch most recently served as Acting Chief of Staff at U.S. Citizenship and Immigration Services, USCIS. He was previously the USCIS Field Office Director at the U.S. Embassy in Seoul, South Korea. He also worked as an immigration officer for USCIS at the U.S. Embassy in Manila, Philippines. He started his career with USCIS as an immigration officer in the Administrative Appeals Office. Mr. Risch, or Secretary Risch, is a former Foreign Service officer with the Department of State, where he served as a consular officer in Amsterdam. He was highly regarded legal career in Pennsylvania, in addition to his government service. He has earned a BA from Bloomsburg University of Pennsylvania and a JD from Dickinson School of Law in Carlisle, Pennsylvania. Mr. Secretary, the floor is yours.
Well, Co-Chairman Smith and Congressman Harris, thank you so much for the opportunity to be here and to speak to you today on the work the Department of State does to prevent and resolve cases of international parental child abduction. My written statement, which I asked to be entered into the congressional record, provides a comprehensive review of our accomplishments and challenges. My colleagues and I welcome your continued interest in the work we do to prevent and resolve international parental child abductions and recognize the importance of your advocacy on behalf of the impacted families. We look forward to our continued collaboration on our shared goals of preventing abductions, expeditiously resolving cases to return children, and strengthening and expanding our partnerships under the 1980 Hague Abduction Convention. After my previous testimony to Congress on this issue, it became clear to me that international parental child abduction was more than simply a consular issue confined to my bureau, and that we needed to do more to ensure that the entire Department of State was engaged on this issue. In pursuit of that goal, and in collaboration with the regional bureaus and our missions abroad, we work across the Department of State to create broad engagement strategies directed at countries cited as non-compliant in the annual reports on international child abduction. We are now completing our second set of these strategies. However, I do want to be clear, Although there is a focus on cited countries, we remain committed to the families of all abducted children, regardless of the country to which they have been taken, cited or not. Our team also works diligently to prevent abductions from happening in the first place, and where prevention is not possible, to assist families in seeking return of their children and to improve conditions in every country to make these returns happen. Regarding the engagement strategies themselves, I want to share where we are headed and what tools we are using, including Goldman Act actions. Each year, we work with the Department of Homeland Security to recertify the list of H-2 visa participant countries. This year, for the first time, the department will also include a country's status in the annual report as a factor for certification. Going forward, a country cited in the annual report that is currently eligible for H-2 visas may be removed from the eligible country list, and a cited country not currently eligible would not be included in the H-2 program. One of the tools articulated in the Goldman Act is the delay or cancellation of one or more bilateral visits. In the spirit of fully utilizing that tool while continuing to engage with foreign governments on international parental-child abduction, where appropriate, we insist that this issue be placed on the agenda and made part of bilateral discussions where it might not otherwise have been. For example, we might insist that child abduction matters be included before we agree to hold a bilateral security meeting. I believe this will send a strong message that addressing child abductions is critically important to the United States government. Our engagement is persistent and forceful. Official public statements are another Goldman Act tool we are looking to make better use of this year. Although we balance the advantage of speaking publicly with the need to work behind the scenes at times, we will publicly highlight those countries which are not effectively addressing international parental-child abduction, as the families involved deserve. Beyond the engagement strategies, we are constantly engaged with foreign partners to improve compliance on international parental-child abduction. Some actions I would like to highlight since the release of the annual report include a visit in May by our Special Advisor for Children's Issues to Egypt to advocate for abducted children and Egypt's ratification of the Hague Abduction Convention. Also in May, the Special Advisor traveled to Taiwan to commemorate the signing of a new Memorandum of Understanding on international parental-child abduction. Alongside these efforts to improve partners' cooperation, we work no less diligently to resolve individual abduction cases. I particularly want to flag one recent example of success in a cited country. It's the same example that you used, I believe. In June, 4 abducted children from 2 families returned to the United States from Lebanon. This came about after significant engagement by the Department of State, including our embassy in Lebanon and our ambassador in Beirut, as well as other U.S. government agencies and members of Congress. These children returned pursuant to Lebanese court orders, a first for that country. Our strategy with Lebanon will be focused on reinforcing this positive development so that other families can benefit in the future. Thank you again to Congressman Smith, Congressman Posey, and Senator Rubio, who engaged on those cases. Their support and your support was greatly appreciated. I believe, as you all do, that preventing abductions before they occur is the best course of action. In the Office of Children's Issues, we have a dedicated prevention team, and I am proud of the work that they do in close collaboration with U.S. law enforcement, especially U.S. Customs and Border Protection. I would like to highlight certain elements of this work. In 2018, we fielded over 5,200 prevention-related inquiries, a 50% increase over 2017, and there are over 45,000 children enrolled in the department's Children's Passport Issuance Alert Program. Separately, we work with Customs and Border Protection on their Prevent Abduction program to stop abductions in progress. Since the passage of the Goldman Act, this highly successful program has been able to stop the abduction in progress of dozens of children to countries such as Mexico, China, and Jordan. In 2018, we enrolled 236 children into this program, and in the first 6 months of 2019, we have already surpassed this number of enrollments. Consular officers are available around the clock, and through our broad public affairs campaign, we encourage parents to reach out for information that can help stop abductions before they happen. Along with CBP, we collaborate at the policy level through regular meetings of the Prevention Interagency Working Group, which last met in April of this year. Participants include the FBI, the Department of Justice, the U.S. Marshals Service, the National Center for Missing and Exploited Children, and others. This group works together on individual cases and collaborative training and outreach. Distinguished members of the Commission, the Goldman Act has significantly reinforced our work to address the complex problem of international parental child abduction. We constantly strive to increase our effectiveness and always look for ways to collaborate with our partners, including you, members of Congress, who have committed so much time and energy to addressing this very important and urgent issue. Thank you.
Thank you very much. I'd like to now yield to the co-chair, James McGovern.
Thank you very much, and I want to thank Co-Chair Smith for arranging this hearing, and I want to welcome everybody to the Tom Lantos Human Rights Commission. I especially want to thank the witnesses for joining us today. We very much appreciate your participation. Let me also apologize in advance for being late and apologize for being late and apologize in advance for having to leave early. The Rules Committee may be meeting again on, I hope not, but it may. So, but the first ever congressional hearing on the issue of international child abduction was held by this commission in December of 2009. And at that time, the U.S. had been a contracting party to the Hague Convention on the civil aspects of international abduction for just over 10 years, and the Goldman Act did not yet exist. The State Department then was working to resolve over 2,000 cases of children who had been abducted from the United States or wrongfully detained while abroad. These were cases where an American parent was denied even the most basic of parental rights, the right to freely contact their child, to visit them, and to see the child develop. Today, thanks in part to the Goldman Act, we have more tools and protocols in place to address these cases from the U.S. side, and the trends seem to be going in the right direction. According to the State Department's reporting, the number of children abducted in 2018 was about half of the number in 2009, and nearly 90% of the cases are closed within a 2-year time period. So there is some positive news there. But there are still hundreds of children and hundreds of parents who are caught in the legal morass of competing judicial systems, intermeshed with differences in culture and social expectations, nationalistic attitudes, and gender stereotypes. Parents' life savings continue to disappear in court costs while their children grow up without them. Even one of these cases is too many. We're here today to discuss what more can be done to help resolve these cases, and specifically what more Congress could or should do toward this end. And I'm particularly interested in proposals with regard to the 6 countries that have demonstrated a pattern of noncompliance for each of the last 6 years: Argentina, Brazil, Ecuador, Peru, India, and Jordan. All 4 Latin American countries are contracting parties to the Hague Convention, while Jordan has a memorandum of understanding with the United States. India, on the other hand, has no protocols in place at all. The U.S. has good relations with and provides aids to all these countries. Do we have leverage with that we could be using more effectively? So let me just close with the following observation. The Hague Convention suffers from a weakness that is common to international treaties. It lacks a supranational enforcement mechanism. Like all treaties, it depends on the political will and good faith of the contracting governments for its effectiveness. But no one argues that the world would be better off without the convention. The debate is how to make it more effective, not less. So I mention this because we're living in a moment when some leaders argue that international treaties, including human rights treaties, are a bad thing. The Hague Convention is a good example of how wrong that thinking is. When problems transcend U.S. borders, we need international cooperation to solve them. And in the case of international child abduction, we need more international cooperation and more political will on the part of governments to fix the problem, not less. Every step we take to reduce the incidence of international child abduction is a step toward greater protection of the human rights of children, and we need to do everything we can. So I thank you for being here, and I thank the witnesses for being here. And again, I thank Mr. Smith, who is a champion on so many human rights issues, for his leadership. I yield back. Thank you.
Thank you very much, Chairman McGovern. I'd like to yield to Commissioner Harris if he has a question. Okay, I have a number of questions, but let me just start off and again thank you, Mr. Secretary, for your testimony, for your leadership, and I know how personally committed you are to this. It's very noble and greatly appreciated by all of us. You know, when we were doing the Goldman Act, when we were writing it, it passed the House twice, failed the Senate through inaction. It took 5 years, which is the number of years it took David Goldman to reclaim his son from Brazil. So it was 5 years for that, 5 years till we finally got it, a period of a decade. At the time, in the U.S. Senate, at one hearing, Susan Jacobs, Ambassador Susan Jacobs, said that in opposition to this legislation, the Goldman Act, that it would threaten the efficacy of the convention, and argued it would delegate the sovereign authority. She pointed out that the State Department has a longstanding policy against the use of MOUs or other bilateral instruments, believing that using them would create a disincentive to consideration of the treaty. Your thoughts on that, because I think, you know, I remember when we did the International Religious Freedom Act, the Assistant Secretary for Human Rights, Democracy, and Labor testified at a hearing that I had in 1997 and said that the Religious Freedom Act, IRFA, would be counterproductive and gave pretty much the same litany of woes. We had the same thing happen with human trafficking. And I am the author of our Trafficking Victims Protection Act, and that was opposed with the same litany of suspected horribles that were proffered at the witness table. One, if you could just set the record straight, has the Goldman Act weakened or threatened the efficacy of the Hague Convention?
No, I don't believe so. I believe it strengthened it. I think the Goldman Act and the tools that it has given us, the attention that it has put upon this issue has been instrumental in our ability to move this issue forward and to demonstrate statistical progress in the right direction, which of course is not the result necessarily leading to the result for every parent that we would like to see, but we do believe it's moving it in the right direction. We think the Goldman Act has been instrumental in that.
Let me ask you with regards to the use of those tools, because DeMarche is used almost to the exclusion of all other of the 18 prescribed potential sanctions that could be meted out. My hope would be, it's just like with our civil rights law, if there's not an enforcement aspect to it, whether it be Title IX or any other civil rights provision in our law domestically, universities, colleges, everyone could just look askance because there is no penalty. So I would strongly encourage, and you might want to speak to it, that a ratcheting up in the use of sanctions in addition to a demarche be seriously contemplated. It'll get their attention. We know that Lebanon moved to release 2 cases, which we had one of those witnesses come here and testify. Mr. Posey, had an amendment to take away some funding for Lebanon, and that sharpened their mind, and then they did the right thing and made sure that this child was returned. I think we have to really use the leverage to help these kids and their parents. So my strongest encouragement would be to look at those other tools that you have and really start using them and let these countries sit up and take notice that we mean business. You might want to speak to that. And while you do, I know Japan was removed. In the Japan Times, they pointed out U.S. removes Japan from blacklist of countries not complying with Hague on child abduction, but remains highly concerned, they being us, remaining highly concerned. I know that, and we have talked about this, there were some aspirational and some legislation making its way through the Diet, which may be good. Who knows if it'll be implemented effectively. But I would ask you sincerely to send a message to the Japanese if they are not robust in resolving pre-Hague ascension cases. I meet with those men and women frequently, and I can't tell you the heartbreak I mentioned Paul Tolan. He hasn't seen his daughter. He was there in Yokohama, serving our nations, protecting that nation, and then got very poor advice from a JAG as to how he should handle the abduction case. His wife passed, and he still has not seen his daughter, who's now a teenager. I can't think, he's there for them and for us, of course, a collective agreement and commitment to peace and deterring aggression. But what a terrible, terrible thing the Japanese government has done in not resolving those cases, including Paul Tolan. So if you could speak to, my hope is that they got upgraded, but it's an absolute conditional upgrade. And if they don't produce, and I mean really produce, I remember meeting over at the Japanese embassy and actually picketing them with a man from California who hadn't seen his daughter, and we couldn't even meet with the ambassador. Then we went with a number of left behind parents from Japan with other members of the Japanese delegation at the embassy. And it was as if they were coming, and they were very respectful, more than I think I would be in their shoes, because the government is part of the obstruction, and they just simply told them, well, maybe you'll get access. And that, to this day, I look back at that. Japan is an ally. Allies don't treat fellow allies with such disdain, especially for the parents and for the left behind children. So on Japan, using those other tools, I would ask finally on the MOU, when I was in Japan meeting with our people there, and I've done this with many, many meetings, I keep hearing how MOUs, they won't work. There are examples like Jordan where we've had an MOU upgraded. They're all, blow off the dust and really make them efficient and say, we're not kidding. And when we start really denying aid, it will make a difference. I'll never forget, because again, I wrote the Trafficking Victims Protection Act. When George W. Bush had the courage and the honesty to put both Israel and South Korea on Tier 3, subject to sanctions for their egregious complicity with human sex and labor trafficking, they worked overtime to get off that list. They closed down brothels in Tel Aviv. The South Koreans passed laws that looked just like ours, and some of them might even be better. So there was a real effort to say, okay, we know you guys mean business. So I do hope you would take that back, and in your very significant leadership role, let's use those sanctions. Let's build up those MOUs. It's a lot of work, but again, you get in the shoes of any one of these left behind parents and sit and talk to them for 5 minutes or 5 hours. You're in tears by the end of it, and I know you are, because you're a very empathetic man. So if you could speak to that.
Sure, I'll start with talking about the Goldman Act actions and how we look at those at the State Department these days. So we've talked previously on this issue, and what I explained before is that when I first came into this role almost 2 years ago and started studying this issue very closely around international parental child abduction and the Goldman Act actions and other steps that are taken, it became apparent to me, as I mentioned in the testimony, that the State Department as a whole did not have a mechanism in place to fairly analyze the Goldman Act actions and how those could or could not be used, or the potential that they had for compelling a country to change its policies or the way it looks at international parental child abduction. Over the many years, this issue was an issue that belonged solely to the Bureau of Consular Affairs, my bureau, fairly so because of its strong connection to consular work and to being central authority and other authorities that we have. But a lot of the issues in the Goldman Act address sanctions and these other things that, while we can influence, are not solely in the control of my bureau. So over the past 2 years, my team has worked across the Department of State to create broad engagement strategies for countries cited as non-compliant in our annual report on international parental child abduction. Each strategy is tailored to the individual circumstances in each cited country. While the focus for these plans is on cited countries, we nevertheless remain fully committed to all families experiencing international child abduction no matter which country the child's been taken to. As I mentioned in the testimony, our engagement plans consider a wide menu of tools and actions, including those in the Goldman Act, which I think is the proper setting to consider those actions when looking at the whole foreign policy package. We insist that international parental child abduction be placed on the agenda of bilateral meetings when it otherwise would not have been. We highlight those countries which are not effectively addressing this issue. For the first time this year, a country's citation status will be a factor in determining whether that country is on the H-2 visa eligible country list. That is one tool that we have where we can message disapproval about a country's performance in this area. Each year, the department works with the Department of Homeland Security to recertify a list of these H-2 countries, and it will be considered this year. With respect to delay or cancellation of bilateral visits, which is also in the Goldman Act, we now insist that international parental child abduction be placed on the agenda of bilateral discussions where it might not otherwise have been. For example, we might insist child abduction matters be included before we agree to hold a bilateral security meeting. The idea is, if we're going to pursue an action under the Goldman Act or otherwise, we believe that the action should be used because we believe it will result in the return of abducted children to the United States. And that's something that needs to be considered by the experts on that country, on that region, in the Department of State, not just the Bureau of Consular Affairs. And we've begun that process last year. We're continuing it this year. And we're trying to make sure that we are adjusting our approach so that it is consistent with the Goldman Act and the actions that are listed there. Would you like me to address Japan next? Sure. So on Japan, you are correct that they were not cited this year in the 2019 annual report because Japan's performance under the convention significantly improved. 2 children returned to the United States under the convention in 2018. And this year, as you mentioned, sir, the government of Japan passed a new law to improve enforcement of court orders, which was really at the crux of their problem under the convention in fully realizing its potential in Japan. We continue to urge Japan to implement that new legislation effectively. But I want to make clear that we remain dedicated to achieving progress on all pre-convention cases, and senior department officials raise these cases at every opportunity. And we are exploring avenues to help those with pre-convention abduction cases, including a possible memorandum of understanding covering pre-convention cases. We have begun that conversation with the Japanese. And it's also important to note that an abduction case is open when Japan joined a convention. Half of the left-behind parents have achieved some access, such as video conferences, exchanges of letters, and in 7 cases, the actual return of the children. But we remain committed to every parent whose child has been abducted to Japan, no question.
Thank you. And thank you for being here. And again, I apologize for being late here, so you may have already addressed some of these issues. Does the State Department track or attempt to quantify the staff and other resources that it devotes to international child abduction cases? Do you have any idea how many people are working on this?
Yes, so within the, I can't cite for you the exact number right now. We can certainly get that for you. But we have an abductions team that works on this at the Department of State. Of course, our consular officers overseas are trained and are aware of this issue as well in the context of the American Citizen Services units around the world. Right. So we have many dedicated professionals focused on this issue. And I think it's important to point out, too, that our prevention efforts, we focus on prevention. Right. So we emphasize preventing abductions whenever possible. Right. And we can be reached at any time by phone. We have a 1-888 number that people can call that anytime. We have email, and all the information is also on our travel.state.gov website.
And I appreciate that, and I acknowledge, some of the progress that has been made already. But I guess what I'm wondering is, are the department's resources adequate to handle this task, given the fact that even though the numbers have gotten smaller, they're still pretty large. The question is, are there enough resources? And I don't want to. I'm not asking you to say that. I don't want to put you in an uncomfortable position, but I think what we're trying to figure out is what we can do here to better assist you and strengthen the State Department's capacity in this area.
Well, I'm
Because,
glad you asked that, Congressman.
okay.
So, I will point out that the Bureau of Consular Affairs, so the bureau where this responsibility rests, is a fee-funded agency. So we don't get any appropriations from Congress. We're funded by the fees that we collect through visas, passports, and other fees, and we build these services into that environment. So the resources are adequate.
So you think they are adequate?
we
That
feel they
you
are
have
adequate.
enough
They're prop-
personnel, and I mean,
They are properly resourced, but the reason why I'm glad you
because it's
mentioned.
okay if you said you want more. I mean, because the deal is, what we want, as we said, I mean, one child abduction is one too many. So, I mean, I think what we're trying to figure out is, are there ways that we can help strengthen the capacity to do more, or are you telling me that you think you've got everything you need?
There will be some proposals being worked out at the State Department, not about increasing any funding, because the funding is something that we're generating through a fee system, but we will be looking and have looked for a long time for legislative action around our retention and spending authority and fee setting authorities. The details are being worked out, but what my policy goal is to try to come up with a better, more 21st century look at the way we're funded, so that we're not as reliant on certain fees, so that we have the flexibility to adequately fund American citizen services, things like this, where we do have, I wouldn't say funding problems, but funding constraints that make it, that ties the services to visa applications and other things that are unrelated to this particular service for the American people.
And are you satisfied that the interagency cooperation is where it should be in terms of prioritizing these cases and helping resolve these cases?
Yes, sir. We have excellent interagency cooperation across DHS and the law enforcement community.
Let me just ask you one other question here. You know, in my opening statement, I talked about Argentina, Brazil, Ecuador, Peru, India, and Jordan. These are 6 countries that have demonstrated a pattern of non-compliance for each of the last 6 years. In answer to a question by Chairman Smith, you had talked about some of the things you're doing in Japan. I guess, these are countries that we all have good relationships with. Are we doing something, unique to try to change behavior in these countries, or
Absolutely,
yeah,
sir.
okay, yeah.
Yeah, so we are engaged constantly in working with these particular countries, particularly the Hague countries, but all of them, really. I personally have engaged on this issue with India, Jordan, United Arab Emirates, and Brazil, in those countries when I have been
But
there.
they don't seem to be changing their behavior.
They,
So we probably need to do something more, I think.
they're not all moving in the direction we would like them to
Right.
move. So, for example, in the 4 countries in the Western Hemisphere, Argentina, Brazil, Ecuador, and Peru, who are convention partners, the problem generally is around judicial issues around how quickly the judiciary moves, and the types of appeals that can be taken, and other judicial issues that require reform. And we're providing support and training and education from a judicial sense, so that those systems can become strengthened and can become more responsive. That's different from, say, India, where they are not Hague partners, and there hasn't been the same type of planning around resolving the cases there as there has been, say, in South America. My point is that these different countries are not, or they're found not compliant for different reasons. And we have to tailor our response and our engagement with those countries based on where the problems are.
And I'll just end where I began, and that is, I mean, part of this commission job, in addition to holding hearings and elevating issues concerning human rights, is to come up with solutions that we can recommend to our colleagues. I mean, this is that we wrote the Magnitsky Act and the Global Magnitsky Act out of this commission. So we're not just interested in having a gathering and, you know, airing some very difficult human rights issues. We want to help and assist and resolve these things. And, you know, as a parent of my kids, you know, and now my daughter's turning 18 tomorrow, I mean, I could not imagine how I would be if my child had been, either of my children had been taken from me. And I would have no access to them. I think I'd be out of my mind, right? And yet, we still have a large number of cases that haven't been resolved. And so one of the things I just would urge you to do is help us help you more, right? I mean, if you need additional capacity, I mean, we want to work to make sure you get it. If you know there's problems with not just intra-agency but interagency cooperation, would like to know about it. We can put some pressure on whoever and you know and try to get a better result. I'll just say, I'm not going to mention the country, but I mean, I visited a country at one point, this was a few years ago, where I had a constituent who had a case where his son had been taken from him and he had no access to the son. And I got to be honest with you, I didn't really get the impression that it was like the #1 priority at the embassy. And I'm not trying to say that to be disparaging. There's lots of challenges that embassies have to take on, but it just seems to me that, you know, with each passing year that somebody is separated from their child, I mean, that's like a lifetime, right? And to be able to have no contact in many cases, that is something that, again, I can't even imagine how horrific it might be. So I don't need an answer now, but think about how we can be more helpful in helping you be able to do this job even better. So I thank you for being here, and I thank the chairman for yielding me. Yeah.
I want to thank you, Jim, for your comments and your recommendations and insights. I just have a couple of questions before we go to our next panel. You know, at the June G20 meeting in Osaka, French President Macron met with some of the affected families and made a public statement on the matter of child abduction to Japan. The Italian Prime Minister, in like manner, talked about the abduction of Italian children to Japan. When I was in Tokyo, I met with and Mary Noonan, my chief of staff, and again, the grandparents of an abducted New Jersey individual, the 2 kids I mentioned earlier. We met with a large group of ambassadors and people from other embassies, and they all had the same problem with Japan. It was like ours is exacerbated because we have more, but it's still the same problem. And so I encourage you, and you did mention the possibility of a MOU with Japan. You might want to elaborate on that. That was great news to hear that. But if there is no movement, I strongly encourage that they go back on the list and next year there be a sanctioning. I do hope there will be sanctioning as well of other countries. You know, Brazil now has a new president. I tried repeatedly to talk to President Lula in Brazil, as well as when he was at the United Nations for the meetings of heads of state. Could not get that arranged with David Goldman. He and I went over to the UN. We tried every which way to just make that connection on behalf of his son, Sean, and yet we were, shown the door, good luck. But now we have a new president there, and my hope is that there will be a change of policy vis-a-vis abduction cases coming out of Brazil. If you could as well, and maybe give a little more elaboration on what this MOU is starting to look like with Japan. The issuance of a one-parent consent passport, the personal appearance requirement in situations where an American child has been illegally abducted abroad. Can you explain the criteria by which the State Department will issue a one-parent consent passport and waive the personal appearance requirement to the child? And secondly, how can a left-behind parents whose child has been abducted abroad bring their child to the U.S. consulate? So if you could speak to that, I would appreciate it.
Okay, could you go back to, what was the first question? It was...
First question was about the MOU.
About the MOU. Okay.
And also, if, again, the Japanese need to know that we mean business. I'm a great believer in civility and cordial relationships, But again, this is an egregious human rights abuse against American children and against their parents. They have gotten away with it for far too long. And so I think, that we need to say, okay, you gave us, your hopes and your dreams, your aspirations of changing your law, which really wouldn't affect, as far as I can tell, those who are pre-Hague Ascension. But if you could speak to that. And then finally, I read very carefully the India, I have another question, the India, and the numbers here are really staggering. And we do have a witness today who will speak to that personally. But as you pointed out, specifically, competent authorities in India persistently failed to work with the Department of State. What? India, our ally, our friend, won't even work with the Department of State? And as a result of this failure, 71% of requests for the return of abducted children remained unresolved for more than 12 months. On average, these cases were unresolved for 2 years and 10 months. Again, they're on the list of violators, but that is a terrible, terrible record.
I'll skip to India first,
Sure.
if you don't mind, sir. So the department continues to advocate for India's accession to the convention. I have personally talked to them about this, and we want them to resolve the existing cases. You're right; it is an increasing number. Without the convention or any other protocols in place to resolve child abduction cases in India, parents often are left to pursue custody of abducted children in Indian courts. Last October, the government of India announced the creation of a mediation cell to assist in the resolution of child abduction cases. They actually announced that to me when I was visiting India to engage with them on this issue last year. While we are not aware of any cases that have been resolved through that mediation cell, we do see it as a positive first step that they're talking about this issue in the context of child abduction and in the context of the Hague Convention. I will say in June, Ambassador Juster explicitly raised congressional concerns with India's new Minister of Women and Child Development on this issue. And there has been also, as you alluded to in Japan, multilateral engagement with India on this issue, because it's not only the United States and our children who find themselves, and left behind parents finding themselves in this situation in India. So we will continue to work with them on this. Hope to see progress, hope to see them accede to the convention and partner with us and build the institutions necessary for them to be full partners. We engage with them on this issue constantly. On the MOU issue with Japan, as I mentioned to you in our meeting a few weeks ago, we have brought this up to the Japanese. I don't have an update for you today on any response at this point, but we'll continue to press them. I do think it's extremely important that we have some kind of appropriate resolution or path forward for pre-convention cases. As mentioned, we do advocate at every opportunity for all parents whose children have been taken to Japan under this in this situation, pre-convention or post-convention. On the one parent issue with the passport application, I don't want to guess as to all the different ways that one can acquire a passport through that mechanism. It is not something that is easily obtained. You would need to go through the process as explained on our passport application website, but we can get you a very detailed explanation for all the ways that that can be accomplished. I'll point out, though, that while I don't have statistics in front of me on it, I do know that there are times when children who are taken out of the United States and abducted, they're abducted using a foreign passport because the child may be a dual citizen. And of course, we wouldn't have control over the issuance of that passport. But there are other prevention tools that I discussed in my testimony could be available.
Thank you so very much, Secretary, and thank you for your leadership. It's greatly appreciated. I do hope, again, next year for the egregious violators that there will be a much more application of and usage of the sanctions. I think, as we saw with the two cases coming out of Lebanon, and that's the most recent. And when I talked to Congressman Posey, he himself was pleasantly surprised just how efficacious it was, that when they realized they're going to lose something, all of a sudden they can find children, all of a sudden they could live up to the obligations that they have, the international norms. So please take that back if you would, because while there'll be pushback, there always is, there's pushback on trafficking when sanctions are meted out, but it's like, we're not kidding. And I know you're not kidding, but I think they take it much more seriously. And again, having you at the helm is very encouraging. We're very hopeful.
Well, thank you, Congressman. Thank you for your leadership on this issue and for standing up for children.
Thank you so much. I'd like to now welcome, our second panel today, beginning first with Patricia Appy, who has developed a practice which is primarily focused on international and interstate family law. She has directed the international litigation of child custody disputes throughout the world. Again, Mr. Secretary, if it's at all possible, given your busy schedule, Mr. Secretary, if you could just check if you could listen to at least some of the testimony. I know you've got a very busy schedule, but if you have any time at all to hear our distinguished witnesses, I don't want to presume on your time, but it would be very helpful. We've got two great witnesses. So if you have any time, it would be great. That'd be great. Thank you. Thank you. Patricia Appy has directed the international litigation of child custody disputes throughout the world, serving clients in a wide range of cases in signatory countries as well as non-signatories to the Hague Convention. Of note, she successfully represented the Left Behind father, David Goldman, and frankly, I can't say enough how deeply I respect the expertise and the tenacity she brought to that fight in bringing Sean home. It's also the case which lent its name to the Sean and David Goldman International Child Abduction Prevention and Return Act. I would also note parenthetically that I relied on Ms. Appy's expertise and input in drafting that landmark bill. Ms. Appy is a frequent teacher, lecturer, and commentator on the complex legal issues arising from international family law. She serves as guest faculty at the Judge Advocates General School of the U.S. Army at the University of Virginia, the United States Naval Justice School, and the United States Air Force Judge Advocate General School of Issues of Advanced Family Law, Treaty Law, and the Implications of Military Service. She has aided in developing legislation to amend child custody law in the state of New Jersey to enhance protections for deployed military parents, for which she received the New Jersey State Bar Association's Legislative Service Award in 2010. Ms. Appy received her legal education at Case Western Reserve University School of Law in Cleveland, received a Juris Doctorate, their JD, in 1986. She has taken continuing legal education at the Harvard Law School Islamic Legal Program on issues of Islamic law and marriage. In addition to her law degree, she holds a master's degree in social work and a clinical concentration in family and children, which she received in 1983 from the University of Missouri, Columbia School of Public Service. She has testified, as I said earlier, at our first hearing and at a few other hearings as well. Again, always providing incredibly useful insights and recommendations. Ruchika Appy has been a legal permanent resident of the United States since 2010, and welcome. She currently resides in Chantilly, Virginia, and has been employed as a cloud solutions architect with Amazon Web Services in Herndon since 2013. Prior to that, she worked as a software engineer for a number of years, following her 2 postgraduate degrees in environmental science from New Delhi in India and computer science from the University of Maryland right here in the United States. Mrs. Appy came to the United States on a student visa in the year 2000 to pursue higher education, and her spouse accompanied her in 2001 with the intent of permanently settling here. Roshi Seth is a U.S. citizen by birth, born in 2007 in Fairfax. She resided with both parents at the marital home in Chantilly. At age 6, Roshni was uprooted from her home by her own father and taken to New Delhi, India, without Ms. Appy's knowledge. The father abandoned his job and permanent resident status in the U.S., refused to return to the U.S. with Roshni, and denied Ms. Appy any access to Roshni for prolonged periods of time. For over 5 years, Ruchika has been desperately seeking her daughter's return to the United States and facing extreme parental alienation issues. She has testified as a left-behind parent for the Committee on Foreign Affairs hearing, Hope Deferred, Securing Enforcement of the Goldman Act in 2016. She continues to be an active member of Bring Our Kids Home organization and I Stand Parent Network, advocating for systemic changes that would help resolve the pending cases to India and prevent abductions in the future. Again, so sorry for the ordeal you have faced, but hopefully today's testimony will be of some help. Ms. Abbey.
Co-Chairman Smith, with earlier reference to Co-Chairman McGovern and the distinguished members of the Commission, I'm honored to have been invited to appear before this Commission for the third time in my career. My first appearance was a decade ago and a full 5 years before the enactment of the Sean and David Goldman International Parental Kidnapping Prevention and Return Act. What the Goldman case had demonstrated to all of us was that in the case of a non-compliant country, no individual parent could be expected to be in a position to litigate their private case and then be forced to fight a diplomatic battle which appropriately belonged on a nation-state's level. What this Commission's work illuminated was that there were hundreds of parents and children similarly situated to Sean and David Goldman, and without legislative action, there would be thousands more. The Commission was the first one ever to address the international abduction of a child to countries which were not yet treaty signatories. Testimony identified many countries with whom the United States enjoyed positive partnership in economic or strategic efforts, including Japan, India, Pakistan, to name but a few, for which the obstacles to recovery of a child were considered total. It was urged that renewed efforts at deterring and addressing wrongful removals and retentions to these countries were overdue. Naturally, all agreed that encouraging the adoption of the Hague Convention on the Civil Aspects of International Child Abduction would be the most efficacious remedy. However, testimony at that time and subsequently documented that there were religious, legal, and cultural obstacles in many of these countries, which would create significant difficulties in their enactment of the treaty or their compliance with it. It was urged at that time that using the diplomatic devices of memoranda of understanding and other bilateral agreements, addressing the nuances and legal and cultural challenges found in many of these family law systems, could fashion protocols to assist in the return of abducted children, while still working to encourage full participation in the abduction treaty. As you have noted in the earlier comments, significantly, the United States Department of State opposed the enactment of this legislation and continued to oppose the use of memorandums of understanding, urging that its enactment would threaten the efficacy of the convention and urging that memorandum of understanding would in some way threaten consideration of accession to the treaty. 5 years later, most certainly it is clear that the earlier concerns of the Department of State were unrealized. The Goldman Act has provided a reliable and necessary component to the assessment of risk and the prevention of international child abduction. My testimony today, which I'm summarizing in my remarks, but would request that the full content be made part of the record.
Without objection, so ordered.
Thank you. Covers three practical areas of consideration for improvement in the application of the Goldman Act, and I would say in response to Congressman McGovern, I'd be delighted to suggest ways that additional resources could be placed to enhance the work that was contemplated and conceived in the Goldman Act. The first is an objective assessment of noncompliance and what actions are to be taken, which in the earlier testimony focus on what is already set forth as the objective outline of diplomatic resources that are to be considered. The Act begins with the word shall, not may. What a good idea. The idea is to be able to review those and assess in circumstances of repeated and perpetual lack of compliance the application of those remedies. The second is to, once again, a decade later, urge the use of memorandum of understanding and bilateral agreements in those circumstances in which treaty signatories obviously are not meeting the reciprocal requirements of the treaty, and in circumstances where there must be some bridge before a cession of a treaty by finding an alternate protocol that addresses existing abduction cases. And finally, my testimony would address an improved implementation of the existing Prevent Departure program, ensuring a more predictable and expedited process for the entry of orders prohibiting international travel and confirmation to the issuing court that a child has been successfully entered into the system. I think one of the disconnects that the implementation of the Goldman Act has suffered from has been a lack of reliance upon practitioners in this field who are actually involved in the court process, who are actually involved in the recovery of children, in providing technical and substantive assistance to the diplomats of the Department of State who are fashioning protocols and remedies. In the 2019 report, 9 countries were identified as non-compliant. Of the 9 countries which are cited for their lack of compliance, none of the recommendations included in the report reflect even the lowest level of diplomatic sanction contained in the federal law. Of the 9 countries included in the report, 8 of them have been included for multiple years as non-compliant, and 2 of them, Argentina, a treaty signator, and India, a non-treaty signator, have both had significant negative developments that may contribute to greater obstacles than those currently identified in the report. Argentina, India, Brazil, Peru, and Jordan have all been cited as non-compliant from the inception of the revised reporting requirements in 2014. In the case of Argentina and Brazil, both were also cited under the prior reporting requirements applicable only to treaty signatories. Nevertheless, recommendation for all of these countries is limited to one of 2 standard departmental recommendations. Either, quote, the department will continue to encourage, fill in the country, to accede to or ratify the convention, close quote, or in the case of Jordan, Lebanon, Egypt, and India, quote, the department will continue intense engagement, which is undefined, with the country authorities to address issues of concern. In the case of Argentina, Brazil, Ecuador, and Peru, their status of noncompliance, in some cases for multiple years, not only implicates the reciprocal obligations of a treaty partner, but begs the question of why the statutory and diplomatic measures enumerated expressly in the Goldman Act have not been recommended, let alone employed. Additionally, in reviewing the remaining information contained in the report, one must comment upon the objective standards being employed in accurately assessing the compliance level given the objective information which has been provided, particularly in the case of a treaty partner. In my written remarks, I've chosen 2 countries to provide summaries of concern. They are by no means to be considered exclusive, and I would be prepared to address issues with respect to specific countries that the Commission may be interested in discussing. The first that I addressed, of course, is the one that you addressed with the Secretary, and that is Japan. The report is forced to acknowledge that unless the taking parent voluntarily complies with a return order under the Convention, judicial decisions in Convention cases in Japan are not generally enforced. An explanation of the inability to enforce Convention return orders is described with the conclusion that enforcement of orders for return under Japanese law is not now presently effective. While the report notes the promising information regarding the passage of implementation legislation in Japan to address enforcement challenges, it appears that Japan was removed from the non-compliant list on the promise of successful action rather than demonstrable, predictable application of the treaty. That's a huge problem because American judges are going to look at the 2018 report, which remember is already retrospective, and make decisions today about protective measures with regard to children. So if they are being told that Japan is treaty compliant, but in fact, there is not an effective reciprocal process, then there is a disconnect that endangers American children. Further, the accounting of cases, which was referenced by the Secretary, would require significant unpacking to get to half of the cases. First of all, understanding that a large number of pending access cases are actually pre-treaty abduction cases in which the parents were requested and ensured that if they made applications for access, that was going to be an expedited process for their ability to see their child, conceded to have been abducted from the United States. So the idea that half of the cases have been resolved belies the fact that a significant number have not only not been resolved, but none have been resolved by judicial process with respect to access. And meaningful action on pre-convention cases remains illusory. I also reference in my written remarks Turkey as particularly important related to this commission. The report on Turkey lists that country as treaty compliant. And the recommendation, which is repeated for most compliant countries, quote, the department and the Turkish Central Authority will continue the effective processing and resolution of cases under the convention, closed quote. It indicates no issue with compliance. However, a careful reading of the description indicates significant difficulties with treaty compliance. The central authority is described as having a cooperative relationship. However, unspecified delays in communication about actions to resolve convention cases are identified as an area of concern. We don't know what they are. We don't know how they impact the cases. Alarmingly, the report indicates that the average time to locate a child was 9 months. The average time to locate. We're not talking about retrieving them or repatriating them. Further, for 3 abducted children, the Turkish authorities remained unable to locate the child. The report also identifies delays by Turkish officials that impacted cases and noted that the Turkish court system does not automatically enforce orders. It is hard for me to understand how, given those objective criteria, Turkey could be deemed to be compliant. Further, and in particular as it relates to this commission, the Hague Convention, Article 20, specifies that the return of a child under provisions of Article 12 may be refused if this would not be permitted by fundamental principles of the requested state related to the protection of human rights and fundamental freedoms. Now, this issue addresses cases in which Americans and others have returned to the United States. The United States Department of State 2018 Human Rights Report identifies significant challenges directly impacting upon the judicial and administrative resources of that country, restricting the exercise of many fundamental freedoms, quote unquote. Specifically, the report identifies compromised judicial independence and rule of law. The Human Rights Report acknowledges that authorities have dismissed or suspended more than 130,000 civil servants from their jobs, arrested or imprisoned more than 80,000 citizens. The Human Rights Report cross-references the Goldman Act report, but provides no guidance as to the impact that these significant human rights issues directly impact on the judiciary, which would be called to address child custody or law enforcement, and address in no way the functioning of law enforcement courts or the central authority as contemplated in the treaty. My recommendation, while the information presented and the content of the reports continues to improve, the role these reports play in fashioning preventative measures require the Department of State to accurately portray the current status of compliance or cooperation, not its aspirational goals. In cases in which countries have been denominated as persistently noncompliant, the provisions of the Act for the recommendation of diplomatic sanctions must be addressed, rather than standard sentences promising increased vigilance. With respect to what things can be done to increase that compliance, and I would indicate should be reconsidered, that is having an ambassador-level appointment for the Office of Children's Issues, a special ambassador appointed to be able to address the issues not only of child abduction, but all children's issues related in particular to issues regarding abduction and adoption, which was removed from the Goldman Act's earlier form, but which should be reconsidered now as we look at the issues of memorandums of understanding. There is no question that having someone at an ambassador level discussing and negotiating memorandums of understanding provide much more attention to that issue than might otherwise happen. The other issue with respect to MOUs that you raised is that MOUs should most certainly be evaluated and updated. Among the non-compliant countries, as noted in my written remarks, 3 of them have existing MOUs, the youngest of which is 13 years old. The content of those MOUs are not readily available. The process or protocol related to them, practitioners cannot access. And frankly, in the case of Jordan, there's no acknowledgement that there's a religiously based system and parallel systems that need to be addressed in any MOU. Finally, I included in my written remarks reference to the Prevent Departure program, which should be utilized much more frequently than it is. And I have to indicate that I do not believe that the interagency cooperation on this particular issue has been effective. There needs to be a standard form of order for use by judges, limited to the placement of the child on the Do Not Depart list. It should be approved by the appropriate authority, Department of State, Homeland, and available on the website of the Office of Children's Issues. Right now, there's no standard order, which means that it delays the time that is taken between a judge ordering the prevention of travel and a child actually traveling. There should be an expedited standard process to notify the issuing court that the order has been entered and is implemented, so that there's no danger that a child is placed in a visitation situation where a court believes that there are border controls and there are not. I would just conclude by indicating, as I have previously testified, my former client, David Goldman, was not the only left behind parent, and I am most certainly not the only family lawyer working to see that families and children are protected from the scourge of international parental abduction. The International Academy of Family Lawyers, of which I am a fellow, the American Bar Association Family Law Section, of which I am a member, continue to provide incredible insight and advice and a willingness to work and provide competent technical assistance to members of Congress and to improve the working of the treaty, to enhance diplomatic efforts on behalf of children at the Department of State, with the ultimate goal to bring every abducted child home and to provide every child with the full protection of human rights in all situations. Thank you.
Ms. Abbey, thank you so very much for your testimony. I'd like to now yield to Ms. Abbey.
Chairman, Mr. Smith, members of Human Rights Commission, members of Congress who are watching live, State Department officials who are here today, and other supporters in the room who have gathered to demand actions and results for the return of America's stolen children. Thank you again for having me here testify today. And thank you, Mr. Smith, for being our champion, for all of your relentless efforts, for your commitment to bring our kids home. My name is Ruchika Abbey, and I'm a left-behind parent, mother of Roshni Seth, who will soon turn 12 years. Roshni was abducted to New Delhi, India by her father when she was a little over 6 years. And she now believes, she's an unfortunate little girl who now believes that it's her mother who abandoned her, it's me who broke the family, and that's why she's not with me. And this is Riley, that is Roshni's companion. You would always see her standing for Roshni with me. I feel I have this huge task today of representing not just Roshni, but all the abducted children, especially those taken to India. 102 of those reported recently, and there's many, many more, we all know. And I'm representing these alienated, left behind parents in the US who are victims of IPCA, International Parental Child Abduction, which is a federal crime. The civil remedies we have, Hague Convention, Goldman Act, we've been talking about that today. They are ineffective, extremely slow, and these are mere pillars of hope for us, hope that things will change someday. And the criminal procedures that are available are not well established either. Many of us don't even know some of those tools exist. And the harsh reality is that the victims of this crime, us parents, we have the onus of solving our own cases. We are left with our own devices to seek justice, to seek return of our kids. We suffer for years. We are ripped apart from our own children, whether we are mothers or fathers, it doesn't matter. And we are completely at the mercy of these abducting parents and also judiciary of India at this point. I have testified with this committee before in July 2016 for Hope Deferred hearing. And after 3 years, 3 more years of fighting since then, I've been begging, giving in. I've been fearing separation from my daughter, who was already snatched away years ago. 3 more years of alienation, heartbreak, disappointment. I concede today that I don't even have any hope left. Hope deferred is now hope lost for me, and I'll never give up on my daughter, but I don't have any hope that things will change, and at this tender age, I'll be able to play a role of her mother in her life. And thanks to the inaction of governments, so-called allies, USA and India, I failed to bring my daughter back. I tried, I pushed hard. I was in India for almost 1.5 years. And this is the time when my daughter wanted to come back, to resume her normal life, to reunite with her friends, to attend first grade, to graduate from Girl Scout and whatnot, but then she was constrained to stay in India and forced to find a new normal and even forget her past, forget her identity. And she is one of the many unfortunate abducted children who don't even know they are ultimate victims of this crime, that they are being robbed of their fundamental right to both parents. They don't even know that. And again, to those who have gathered here today and are listening on the live stream and know what IPCA is, and for the heinous crime it is, and violation of human rights and damaging our children's, self-esteem, I really urge all of us and all of you to demand immediate action from the Department of State, the Secretary of State, our government, from President Trump, from all of these other agencies we've been talking about, Department of Justice, Homeland Security. Yes, there have been efforts, but they're not enough. It's time to escalate efforts now. Time is not a luxury for our children, and they're losing precious childhood, and we cannot just talk. We have to do something about it, and I know that's why we have gathered here. I would like to focus on my story, Goldman Act at 5 years, and where I am with my daughter's abduction, also at 5 years. When the act was signed 5 years ago, I was starting this long-run battle in India a few months after my daughter was abducted, and I saw hope. I thought things would change. Things will be, really speedy now, but little did I know 5 years after I'll still be sitting here and begging for action from US government, India, everyone. After enduring multiple proceedings in multiple courts in India, including the Supreme Court, which is the apex court, highest judiciary of India, after my daughter went through 8 interviews in these courts, after obtaining several favorable orders for visitation and custody that were willfully disobeyed and never enforced by the judiciary, after 2 rounds of petitioning in US, after spending more than $150,000, after 3 failed mediations and 1 successful mediation recently, I'll give an update on that, where I agreed to give up all my custodial rights in US just to have access to my daughter so I could be included in her life as her mother. I still don't have any hope, 0 access, nothing, everything failed. And I have 0 hope that things will change. My previous testimony records everything from abduction to what happened after 2 years, but just to summarize before I fill in rest of the details, it happened in April of 2014, and my ex-husband, at that time, he disappeared while I was traveling to North Carolina for a business trip, and I had to declare a family emergency, come back to the emptiness of my home, and from there this nightmare started. And he was planning this for months without my knowledge. He used brute force attack to get me to get my daughter out of CPIAP program. And he fled US because he was trying to get away from DUI violation charges, anticipated jail time. I saw all that coming, but I still could not protect my daughter. And after that, I spent 1.5 years in India. My daughter was with me for some time in India because High Court gave me her custody, but they restrained her travel, so I could not bring her back. I went for 3 months. I stayed there for 8 months with my daughter at my parents' house, but I was following every single visitation order. And at that time, I saw my daughter. She had this separation anxiety that she never had before. She wouldn't talk, but she started expressing her emotions through drawings like this one that show some sort of distance between a mother and a daughter, and her fear of separation. Here they're trying to be together, but they can't be. But she was taken again because I had to come work. I couldn't pay my legal bills, so as soon as I traveled to US, she was abducted again, all contact broken, and that's when I lost her, not just to abduction second time, but also to alienation, because she was made to believe that I left her behind, I abandoned her. And after that, I just went from court to court. I went through Supreme Court, and there was a finding that Roshni was tutored by the other parent, but she was still sent back to the alienating parent. And every time she was interviewed, she came out of that interview empowered. Now my daughter thinks that there is no court who can send her to me against her wishes, and her wishes are, we all know she's projecting someone else's wishes. And that's what happened. And the fact that I did not get a hearing in India didn't break me, but the fact that she turned away and she didn't look back, that broke me, and I came back empty-handed. I couldn't bring her back, and I kept fighting in the family court. So High Court, Supreme Court, now family court, and that's when I testified here as well. I was just waiting. After that, I did have a breakthrough in family court. Family court dismissed the father's guardianship petition on the basis of the fact that India did not have jurisdiction. But to my dismay, they could not restore her custody, and I still had to keep fighting now in the High Court. I visited many times. Despite having visitation orders, I could not get any access to my daughter. And then in 2018, last year, I urged the High Court to intervene and give me at least access to my daughter. And that's when I went through a series of chamber hearings. And the judges proposed, come to a mutual compromise, just work on an arrangement. And I agreed. I agreed to every single term that the abducting parent and his attorneys proposed. I agreed that Roshni will stay in his custody in New Delhi, India until she turns 16, and even after that it would be her discretion to come with me or come to me in US. And all I asked for was visitation access to her, and that she should at least visit me in US. And I agreed that I would end this tug of war and I would send her back to her father. I agreed to give up my sole custodial right here to reassure everyone that I will send her back. I agreed to everything. I had my doubts, and there were times when, at that time, I got access to my daughter, and now she wanted me to sign that piece of paper so badly. She was emotionally blackmailing me. And I was determined to go to any extent for her, and I did. And I did sign that agreement. Just before I did that, a year before, on top of everything, I lost my mother. My mother had a special bond with Roshni. She was watching my live stream last time I testified. And talking about cruelty of abducting parent, I did not get to meet my daughter as I was grieving for my mother. My mother did not get to see her for 18 months while they were in the same neighborhood. So it's not just alienated parents, but grandparents, family, siblings. It's just a curse that we have to cure. Here I am today, talking about that settlement. I did come back to the US, and my attorney, Mr. Zuckerman, is also representing me here and supporting me here today. He had me file this motion to acknowledge the terms of that settlement order, which seemed like a very unfair settlement, but then I did file the motion for reversal of the custody order. And what I didn't see coming was that the court, when I filed that motion, I testified and I got questions why a parent who was deemed unfit by the same court on the account of his background, domestic violence, anger issues, DUI violations, kidnapping, not letting me have a relationship with my child, showing utter lack of parental judgment, why all of a sudden I am now ready to give him sole custody in India and in US, what's going on? The judge couldn't understand. He took 50 minutes to go through all the previous orders, and then he denied that motion, and I didn't see that coming. Nobody saw that coming. I was planning for my daughter's visit in summer, and this motion was denied. I was given an option for getting a guardian ad litem, a GAL attorney who would assist the court in determination of father's capability as a fit parent. And I almost said yes. I was so eager to make this work. I said yes, but then I took a step back, and thanks to Mr. Zuckerman and his advice, I realized that I cannot commit to spending an unanticipated amount of money to make things work, and they may not even work. You know, he would again say the child doesn't want to come to US and visit you because it's all about her wishes now. So I drew a line there. I stopped. I did not do anything, and I went back to India in May. I told them I tried to comply. I'm here, but it's not in my hand now. And the judges are not happy, and again, the father is angry. Again, I have no access. My daughter is disheartened and angry at me. She thinks I'm not making things worse. I am making things worse for her. And I have stuck a wall again. I have hit a wall again. I don't know where to go from here, and I'm here before you. My daughter is staying in Paharganj. I don't know if you've heard of it. It's a very crowded neighborhood. I worked really hard to get out of that neighborhood 20 years ago, and the irony is that my daughter is now there and I'm helpless. I cannot change anything about her spending her childhood in a neighborhood which has increasing crime and whatnot. we've gone over the report and everything, so I'm not going to get into that, but we saw and we heard Assistant Secretary Reich talk about the mediation cell in India. I would like to, and Ms. Appy said some negative developments. I would say that is one of the negative developments. That mediation cell is nothing but a hogwash. I have gone through mediation 4 times now. The parents are going through it. There are no decisive next steps if it fails. It is voluntary. There's no mandatory aspect to it. No time-bound framework. Parents who have gone through the process, they couldn't even establish digital contact with their child, let alone coming to a conclusion through that mediation cell. So I would definitely say that is not working and is a negative development. I also would like to highlight one thing here. India keeps bringing up Hague Convention as anti-women, and it is rooting for women, saying they're fleeing away from violent marriages and abuses. And they're ignoring mothers like me who have gone through domestic violence here, who are dealing with this ultimate abuse of separation from their kids. And Chairman Smith, you spoke about Bindu Phillips. Dr. Rahman is in this room. I work with a lot of left behind mothers. My heart goes out to Nidhi Soni. I would like to call her out. And her son, Daksh, who was abducted twice from India to US, US to India. Now he's in India with his grandparents because the abducting father committed suicide 2 years ago. And the absurdity is India allowing aging grandparents to fight custody battle and not giving Nidhi any access to her son, who is forced to believe that her mother is a ghost, her father is dead, and her mother is a ghost. And Nidhi is asking for, requesting State Department for that passport thing. You brought that point up. There is no way kids who are abducted can be present for their passport issuance. And there are other parents who are going through this. So in these extraordinary circumstances, which they are, we have to do something about it. So I would like to call your attention on that. Again, call to action, I would definitely urge you and Department of State to work with other agencies and find ways to prioritize return of our children immediately. I would like to urge President Trump to intervene and do something about our American children having illegal status in other countries. In India, they don't have passports, no visa. They continue to stay there. They need to be brought back home immediately from all countries, whether it's India, Japan, Brazil, or all of these other countries quoted. I do want to leave a note for my daughter, if you would allow me just 1 more minute. I don't have any other way to connect to her. I know she's not listening to this, but I know she will one day. And before I say something to her, I want to set the context here, if you would allow me. When I came to US, I didn't have any money, so I had to come back to work so I could go back and fight. And she was very strong, and she told me, yeah, Mama, go, take my bear with you. That's when she gave me the bear. Yeah, I'll be fine. But the night I had to leave, she was crying, and she questioned, why do you have to go and leave me? And I didn't know what to do, so I put her to bed with a story that she could relate to at 7 years. And I told her that, Roshni, listen to this story and always remember, there's a small family of frogs. They were wandering in a beautiful forest, and they fell in a deep, dark well. And now the only way to get out is if the mama frog goes out of that well first, and then bring back help for the baby frog. And the baby has to know that the mama will come back until the frog gets out. And I thought she would relate to it, and she did, and I thought she would remember. But when I went back a month after, she didn't even talk to me, look at me. I don't know what happened in that 1 month. And with that, I just want to tell Roshni, and please know that I am so sorry that I had to leave you with your Nani, who's my mother, who's no more now. I dropped everything. I came back for you. I came back many times, and I will keep coming back. I haven't forgotten. I haven't left you. I will keep coming back, and you'll see the world soon. I really love you, and I miss you. Please, thank you. Thanks again, everyone, for being. If you have any questions, Mr. Zuckerman will be happy to answer.
Thank you for your testimony, both of you for your testimonies, for again underscoring the anguish that's associated with child abduction, for pointing out the hypocrisy and the mediation path, which even in the State Department report, which it called first a significant development, then points out that the U.S. is not aware of any abduction cases that were resolved through this service in 2018. And of course, you have spoken to that as well. I do hope, we need to ratchet up our pressure on India, all countries that are, including Japan, that are not compliant with these internationally recognized standards and really obligations. My hope is, and I strongly encourage the administration to use the sanctions. No game playing, use the sanction, let it be predictable, let them know it's coming, and then do it. I mean, India is a democracy. I have great respect for the Indian people, but when it comes to their performance policy-wise, from the judges to the parliamentarians to the prime minister, it is a profound disappointment in India. When Bindu Phillips was here, I actually walked her over to meet with Modi for a short, but I think was hoping to be a positive interaction. He listened and nothing, I say again, nothing happened. Where's the heart? Where's the empathy for a mom like yourself who has suffered so much? I mean, this is cruelty. This is child abuse to have your child abducted like this. And I think we need to now take the sanctions that are embedded in the Goldman Act, the other tools that are available, including extradition, and perhaps Patricia Appy might want to speak to all of these tools, including extradition, and whether or not we need to significantly ratchet up the pressure. I, for one, and I know people in this room can't sit here and listen to your appeal and not be moved profoundly by it. So I thank you for sharing your heart, broken as it is. And your daughter someday will hear this. This is being recorded. God willing, we'll get to see it, to know just how much you love her. But if you could, Patricia Appy, speak to that, if you would.
Well, with respect to, first of all, with respect to India, because it wasn't part of my primary, India was not part of my primary remarks, I'd just like to make a couple of observations. First of all, I completely agree that the suggestion of mediation as a positive step in this particular context is nothing other than a bait and switch. In fact, Japan used the same mechanism, suggesting that parents submit their cases to, quote, mediation, when in fact there was no enforcement available There was no regulations covering this, and understand that for mediation to be successful, and obviously it's used successfully in resolving family disputes all over the world, but it's based on the proposition that both parties can come to the table on a level playing field and not under duress. What you have just heard doesn't represent a mediation. It represents an extortion. And the difference between those two cannot be something that in looking at a country's compliance, we in any way, shape, or form give an admonition that extortion of those parents who have been victims of abduction and those children will be countenanced as positive effort. I would mention that there are difficulties with extradition, because our federal law that addresses international child abduction requires the existence of an order that sets the custodial rights and a willful breach of that order in order for it to be considered a criminal act. A large number of cases of abduction occur not post-judgment, but pre-judgment. So certainly extradition in cases where the criminal case can effectively be brought by the United States Attorney is something to look at. I would say that in virtually all cases, family law issues, which erroneously abductions are often categorized as, are exempted from normal extradition treaty, and very often public policy exceptions are used as the basis for not considering the extradition of a parent who's abducted a child. In very many cases, it's not considered criminal behavior at all. I would also note that the other negative context of what has been happening in India has been the perception among many that India is not growing toward the convention but away from it. Respected members of the Indian bar have actually spoken publicly about their lack of support for accession and have lobbied, as was referenced in my earlier comments, against the use of the treaty. That's disturbing for the world's largest democracy. It's disturbing that a judicial system is moving away from recognizing and protecting rights of abduction. This is precisely the kind of case where the sanctions that are set forth in the Goldman Act would have their most effective consequence. Back when we started this process a decade ago, there was a resolution by the House of Representatives that was supported by this commission, which censured Japan and indicated that the treatment of American children who have been abducted was not going to be countenanced. It was going to be made publicly visible. I believe that India is at the place where similar sanctions have to be considered. There's already a mechanism. I think that there's the testimony that was provided indicating a lack of a process in order to apply sanctions was extremely disturbing to me. I understood the complexities of walking a proposed sanction through the entirety of the United States Department of State. I understand that when you're talking about human rights violations, they come up against other strategic interests. However, I think that there has to be, especially among our friends, there has to be a recognition that when we are talking about significant numbers, and I will tell you, these numbers, I mean, we have 7 children this year out of New Jersey. We have numbers that are significantly high, and they are not representative of the total numbers. One thing to remember about the numbers that the Department of State has, it is only those cases in which parents know and understand that they are contacting the Department of State believing they will receive assistance. Many parents are advised that there's nothing the Department of State can do in many of these cases, and it's a waste of time to go forward. The position that most parents are in is one with lack of resource, is one where they have no choice, is one where the child is kept in the country. These are precisely the circumstances in which an individual parent is powerless. It has to be done on a congressional level. Human rights violations are rarely changed by the litigation of an individual. They are changed because there is a will and a political will to stand up and say this far and no further.
Let me just, one of my lessons learned over the years on human rights is that when we go timidly, the human rights abuses get worse. When we were, and I had all the hearings on the International Religious Freedom Act, the Clinton Assistant Secretary for Democracy, Labor, and Human Rights sat right where you're sitting and said that if we pass this, it will do harm to religious freedom around the world. That it would set up a hierarchy of human rights where others would be displaced. And I asked him directly, it's in addition to, it's not in lieu of. When we passed apartheid sanctions against South Africa, it didn't displace anything else. It just was in addition to. It's more human rights and hopefully robust human rights. Now, when the trafficking bill came up, and it was my bill, Harold Koh sat in meeting rooms like this one, I think it was in 2172, and on the record, he was Clinton's point person for human rights. He is a noted human rights advocate from Yale, and he said that we just need to add some additional language to the country reports on human rights practices, and again, that foolish reprise, in my opinion, that all of the contemplative language of the Trafficking Victims Protection Act, like the TIP report, like an office dedicated to, it's now about 70 strong, sanctions that could be meted out if there was a tier 3 country, even the tiers themselves, all of that was counterproductive and would hurt our efforts on human trafficking. That mindset, sadly, pervaded with the Goldman Act. That's why it was opposed so vigorously in those early years. But I am always concerned that there's a vestige of believers who believe that if you sanction, they might get mad and angry and it might hurt our bilateral relations. I would argue contrary, and I would appreciate your thoughts on this, that it is when we are clear, precise, predictable, and strong. And of course, we have a human rights basis. Listening to Ms. Abbey talk about her heartbreak, I mean, how could anyone who hears that story not want to say, we got your back? Well, we have, again, a redo again here where we're not using sanctions that are fully available to us. If India is not sanctioned, let them push back. Seriously, let them push back. Let Japan push back. We've got Japan's back with the abductions of Japanese to Pyongyang and to North Korea, as we should. And the president has spoken about that many times, and I'm fully with him on that. But what about the Americans whose children have been abducted to Japan? Or in the case of India, those cases as well. So, I mean, I can't say it's strong enough. You know, one, the laws, all three of them, and I worked on all three. I'm the author of two of them. Frank Wolf's the author of the Religious Freedom Act. I did trafficking and the Goldman Act. They were vigorously opposed throughout the entire process. As you know so well, because you lived it, 5 years to finally get the act, the Goldman Act, out of the Senate and passed. Hillary Clinton was against it. It wasn't until John Kerry became Secretary of State that there was a change of heart at the U.S. Department of State. But again, the vestiges of, well, don't use those tools. Why do we walk on eggshells and not use all means at our disposal prudently and judiciously to ensure that we've got the backs of Ms. Abbey and so many others like her?
I would just comment that this report, the 2018 report, was released the first week of May. Within a week, on the cover of Japan News, was an article with headlines indicating that Japan had been taken off of the U.S., as they called it, blacklist. It's clear that these types of sanctions and censures are immediately reviewed and place an important chilling effect on those overseas. to suggest that they are meaningless, that they do not have import, is not a realistic response. The idea that somehow, and frankly, I would say that it's a general pushback from the professional diplomats at the Department of State. I do not believe it's very different, with great respect, between administrations. There is a general view that there is more to be gleaned with honey, as they say, rather than vinegar. But here's the problem. There is no constituency for this particular issue unless you create it in the context of sanctions, like much of international human rights. You have to create a buy-in. And if it's not going to be done because people believe that it's right, then it has to be done because we are going to stand and say that it's wrong. And while I understand that there are sophisticated diplomatic issues that must be considered by the Secretary of State, the fact of the matter is, this is a place where that action we have demonstrated is effective. And in terms of dealing with countries that have demonstrated recalcitrance, or more concerning, are drifting away rather than toward the treaty, there has to be an idea that, yes, we will come alongside, we will bring those who are familiar with the system, we will assist you in legislation, we will assist you in drafting an MOU, we will find ways of doing this, but if you will persist in failing to support the return and repatriation of American children, you're going to know that we take it seriously. And just looking at this commission, among the members of this commission, there are 111 children from these states that were abducted in 2018. 111. Everybody in this body should be screaming about the circumstances when we have an uptick in numbers in a place like India. There should be actions taken, for example, with the United Arab Emirates, which went on the list, but where there are very plausible fixes that could be done if an MOU is negotiated, because they have a strong enforcement process for foreign orders. It's obvious to me that no one is working that problem in a way that is constructive as it relates to the technical issues. We've got to look at this from the standpoint of working the problems and using what is in the Act, not merely just producing the report and hoping for the best.
Is there anything to add? We need to be looking for some tools if the administration does not want to, especially vis-a-vis Japan, or in this case, India, which is on the list. There are things that congressmen and women and senators can do. We know that the F-35s vis-a-vis Turkey were suspended because of the purchase of Russian surface-to-air missiles. I mean, there's a whole raft of suggestions, proposed purchase of F-35s to Japan. Honestly, it should be on the table. We're talking about possible limitation of, maybe not wholesale blocking it, but it is time we got serious.
Well,
We're
and
not
this-
serious enough.
I'm sorry, but this commission is in a unique position because of its focus on human rights. As I said, to be able to link in the report the human rights violations and the human rights concerns with the impact that has on the application of the treaty, the application of litigation to return children, and the access and rule of law issues. Your recommendations on other areas of human rights are going to have a direct impact in the assessment of the reciprocity of treaty.
Anything you'd like to add before we close?
I just wanted to bring up a list of overt actions that I have included in my written testimony, also on behalf of Bring Our Kids Home and collectively on behalf of all the parents. And that does have, in case of India, imposing visa restrictions and halting trade concessions for other countries. So when talking about measures, I would urge all these agencies to look into those extreme measures and have those restrictions remain in place. I think that's important until we see action and until we see kids come home. We haven't seen any kids come home. based on all the persuasive efforts from State Department so far. We do thank them for those efforts. The visit that was reported by Secretary Lawrence to India and other countries. We do appreciate the quarterly calls that we have now with State Department, all IPCA stakeholders. We had one this morning. Ambassador Juster also chimed in. So we do appreciate those efforts, but we need to escalate efforts now. I can't emphasize enough, time is of essence. I've lost 5 years, my daughter has, but I would love to see kids coming home promptly, and I would love to see kids not being abducted in the first place, so the preventative actions and measures, those should start working. And that's where I will close. Thank you so much
Thank you.
again for hearing me out.
Thank you so very much, both of you, and certainly to the Secretary, thank you for his testimony as well. Without objection, the testimony of Ravindra Parmar, whose son is now 7 years abducted, to India, that testimony will be made a part of the record. The hearing is adjourned.